on this, but it's always concerned me when I see a prime rate of interest or a rate at which money is made available to the mortgagees or the lender's best risk or most creditworthy customers, if that lender then loans to some of its borrowers at prime less a half or prime less a quarter. And the concern there is if you do loan to some of your customers at prime less a half, then perhaps that lower rate becomes the prime, notwithstanding the declaration by the mortgagee that of a particular prime rate. The second part is the differential, the base rate plus whatever, which is labeled as B. Most of the mortgages provide that the actual rate will be the base rate plus blank percent per annum. And as long as you remember to fill in the blank, you can't run into too much difficulty, except that I think some of the mortgages that I've seen do not use the words per annum. Section 4 of the Interest Act basically says that in a contract, you must provide for a rate per annum, and if it's at a rate less than per annum, it must show the equivalent per annum, or else you get 5%. But Section 4 doesn't apply to mortgages of real estate. Nevertheless, so you don't have to worry about Section 4 if you leave it out, but I think for certainty it's prudent to include a reference to the prime rate plus a certain percent per annum. The third part is the frequency of calculation of interest, designated with the letter C. In each of the three mortgages we're looking at, the designation is, or rather the wording is that it's calculated monthly, and in two cases not in advance. I think there's more confusion about the words calculated monthly than probably any other single part. And it does not mean, in this context, how often the mortgagee actually works out what the interest is. It really doesn't matter if the mortgagee works out mathematically and attempts to determine what the interest is at any time, because it doesn't affect the mortgagee's yield or the cost to the mortgagor. What is important is the frequency of calculation or compounding of interest. I think most mortgagors probably understand the concept of compound interest after default. If you owe $100 in interest and you don't pay it by the date it's due, then that $100 will itself bear interest, compound interest, so he's paying interest on overdue interest. But what I think a lot of mortgagors do not understand is the significance of the frequency of calculation or compounding before a default. The more frequently the mortgagee can calculate or compound interest, the higher his yield and the greater the cost to the mortgagor, especially in situations where interest rates are high or where the principal amount is great. For example, 10% per annum calculated annually is equivalent to approximately 10.47% calculated monthly. When you look at 20% per annum calculated annually, that's equivalent to 21.94% per annum calculated monthly. So at the 20% rate level, there's almost a difference of 2%. So I think you can see why it's very frequent now for mortgagees to specify that interest is calculated monthly, rather than, I think, as several years ago, where they tended to be calculated semi-annually or annually. The draftsmen of the Interest Act certainly were aware of this situation, and that's why they drafted Section 6 the way they did. If you've got a blended payment, then you don't get any interest unless you show in a statement the interest calculated annually or semi-annually, not in advance. It's a disclosure provision to permit the mortgagor to compare and to know exactly what he's paying. The Kinross mortgage provides that for monthly installments of principal and interest, and therefore I'm sure to many mortgagors would appear to be blended. It also provides for interest to be calculated monthly, not in advance, and therefore you could say, well, have they fallen into the trap and do they comply with Section 6? Marty's talked about the Supreme Court of Canada decision in Kilgorn and Samick as it was interpreted by the Ontario Court of Appeal in Tilson and Doherty. And I think from those two decisions, it's pretty clear that if interest is calculated and payable at the same time, and provided the payments are applied firstly to interest and secondly to principal, then you do not have a blended payment. Therefore, you do not need the statement. So you've got monthly payments of principal and interest, which to the layman may appear to be blended, but interest is calculated monthly, not in advance, and payable monthly, not in advance, and therefore not blended. However, with any new concept. I suppose everyone wants to take as much care as possible in drafting his document, and therefore what most of the draftsmen of variable rate mortgages have done, apart from providing for monthly calculation and payment of interest, they have attempted to include that table of equivalents, which sets out the rate of interest calculated semi-annually, not in advance, which is equivalent to the wide range of rates calculated monthly, not in advance, which are possible under the mortgage, 5 to 30%. That's also the reason why most draftsmen include in their variable rate mortgages a statement showing the actual initial interest rate calculated semi-annually, not in advance, which is equivalent to the actual initial interest rate calculated monthly, not in advance. I think, though, it's not just because of that the draftsmen have included these statements. I think that most mortgagees have attempted to provide as much open disclosure as possible to the mortgagor, because it is a new financing instrument to most mortgagors, and I think they have attempted to include in these schedules as much information as possible. Even the description I see in the Carnwath mortgage of the way in which, the mechanics which the mortgagor can go through to attempt to determine for each payment he makes how much is interest and how much is principal. Just before we leave the calculation or frequency of calculation of interest provision, I'd like to mention briefly the deemed reinvestment principle. I think Nancy will probably be discussing it with you later, but the deemed reinvestment principle only applies if interest is payable more frequently than it is calculated. So interest is payable monthly, but calculated semi-annually. In both the Carnwath and the Canada Trustco mortgages that we're looking at, interest is calculated monthly and payable monthly. The frequency of calculation and payment are the same, and therefore the deemed reinvestment principle does not apply. Some draftsmen who may not be aware of the significance of the frequency of calculation of interest may omit that and provide for a certain rate, but not the frequency of calculation of interest. In that situation, it appears from Metro Trust and Marenish that if you leave it out, then the mortgagee will be deemed to calculate interest when interest is payable. And that's consistent with, for any of you who do any work in the money markets, most notes and paper in the short-term money market do not say frequency of calculation of interest, but the practice is to calculate it when it's payable. And Marenish essentially holds that to be true as well with mortgages of real estate. However, I think for the draftsman, it's prudent to specify the frequency of calculation of interest and not rely on this deeming provision. So you add this together, and in the well-drafted variable rate mortgage, you have a clause which basically says the following: that interest is payable at an annual rate equivalent to, say, 2% per annum in excess of the mortgagee's base rate, calculated and payable monthly, not in advance. That the payments will be applied firstly to interest, secondly to principal, and that at the date of the mortgage, the mortgagee's base rate is, say, 15% per annum, so that the initial interest rate is 17% per annum, calculated monthly, not in advance, which is equivalent to 17.6138, etc. percent, calculated semi-annually, not in advance. And those are the basic ingredients of the interest provisions of the variable rate mortgage. I guess the question is, does it work? If you draft it properly, are you going to comply with all the provisions of the Interest Act, or are you going to run afoul of some of them? I've talked about Section 6, and Marty has spoken about Section 6, and I think that's one of the major concerns, but you've got interest calculated monthly, payable monthly, you apply firstly to interest, then to principal, therefore it's not blended, therefore you don't need the statement. In case you do need the statement, it's there, and there's a table there as well. So they tried to overcome Section 6, or comply with Section 6 in that way, if necessary. In Section 3, Marty just mentioned that briefly. I think Section 3 gave a great deal of concern to many draftsmen initially, because it seemed to indicate that if you don't have a rate which is fixed, then you only get 5% per annum. But the courts have held that fixed doesn't mean fixed as opposed to floating, but fixed meaning determinable. And I think Marty mentioned as well in British Pacific, Mr. Justice Glaskin indicated that he would regard Section 3 of the Interest Act as applicable only when there is no provision made in an applicable statute or in an agreement, and no mechanism is provided by which the rate can be fixed. So as long as there's a mechanism by which the rate can be fixed, as there is in the variable rate mortgage, then Section 3 would not apply. And I think there have been other cases as well, which I won't go into in detail, but have commented or dealt with LIBOR rates, which is a floating rate, the Royal Bank prime rate, and one case which dealt with a rate, well, with an amount that fluctuated with a consumer price index, although in the latter case it was held not to be interest. I think the variable rate mortgage is a useful financing tool, and the courts would likely recognize the commercial reality of that kind of financing tool in the present economic climate. The only other section of the Interest Act which bears on the variable rate mortgage, sort of, is Section 8, which indicates that you can't charge a higher rate of interest after default than before default. But in each of the mortgages that we're looking at, which I think are designated by the letter D, or F rather, the rate that applies is applicable both before and after default. And most mortgages say that it's applied both before and after default, maturity, and judgment. So far, we've been looking at the variable rate mortgage from the mortgagee's perspective. But just for a second, I'd like to take a look at it at the mortgagor's position. I think the first thing that it does is that it takes the guesswork out of arranging a mortgage. The mortgagor at the moment has to predict whether he thinks interest rates are going to rise or fall. If he locks himself in for a lengthy term and interest rates go up, then of course he's going to lose, or rather he'll gain. If they go down, then he's going to lose. With a variable rate mortgage, the mortgagor doesn't have to gamble with the rates. If they go up, he pays more, but if they go down, he benefits from the drop. Second problem could be that in many of the variable rate mortgages, the monthly payment of principal and interest is not fixed, but varies with the interest rate. So if interest rates go up, more interest is payable, and therefore the monthly installment of principal and interest is greater. And I think this could probably work a hardship to any mortgagor who has to budget carefully. And for that reason, I think that the Kinross mortgage is actually very creative. I think what it does, it gives a fixed payment of principal and interest throughout the term of the mortgage, even though the interest rate will climb. So the mortgagor rather, has the security of knowing what he's going to have to pay each month throughout the term of the mortgage. But there is a cost to that as well. And I think it's very important if you're advising a mortgagor who is getting involved with a variable rate mortgage that you explain to him exactly what that cost is so he can make his decision. If the rates increase sufficiently, it may be that the mortgagor will end up paying more interest throughout the term of the mortgage than he otherwise would. For example, if you take a mortgage with a principal sum of $100,000 and a rate of 17% per annum calculated monthly, not in advance, and his monthly installment is, say, $1,500, then at the beginning of that mortgage, you'll find that of that $1,500, probably about $1,416 would be used to pay interest, and $84 would be used to reduce principal. If the rate is then increased to 19%, then the amount of monthly interest accruing is $1,583, $83 more than the $1,500 a month he's paying. So the amount of his payment each month isn't enough to cover the accrued interest. That accrued but unpaid interest itself will usually bear interest at the mortgage rate. Certainly, if you look at paragraph 5 of the Kinross form, you'll see that that accrued but unpaid interest is defined as deferred interest, and that deferred interest itself bears interest. So even though the mortgagor is not in default pursuant to the terms of the mortgage, he's paying compound interest. So with every payment he makes, he becomes further and further indebted to the mortgagee. So it's really a fly now, pay later type plan, but he does have the security of knowing that his monthly payment is fixed. And that may be a real advantage to some mortgagors in some financial circumstances. The important thing is that he understands what he's paying to obtain that certainty. If the rates go up sufficiently high, it also creates a real problem for the mortgagee, because as the accrued but unpaid interest increases, the mortgagor's equity decreases, and therefore the mortgagee's security decreases. And if rates went up very, very high, the mortgagee could find that he could not sell the property for the amount which was owed to him for deferred interest and principal. Kinross has covered this in paragraph 12F, which is designated with the letter H. In the form that was handed out with the CIBC Mortgage Corporation, it's actually paragraph 11F. And basically, what the provision says is that Kinross can call its loan if the mortgagor's indebtedness to both Kinross for interest and principal and deferred interest and any prior encumbrances exceeds a certain amount, which is called the designated amount. And that designated amount will undoubtedly bear some relationship with the market value of the property. I won't go into the detailed provisions of that, but it essentially says that if rates go up sufficiently high so the mortgagor's equity drops, Kinross can call the loan. And I think it's important that each mortgagor who enters into a transaction of this type understand that that is a risk as well before he signs on the dotted line. I was also asked to touch briefly on some of the alternatives to a variable rate mortgage in this kind of economic climate. I suppose that the most obvious alternative, and one which I think is probably being used universally, is the short-term mortgage. Certainly when my parents were buying a home, it wasn't unusual to enter into a mortgage with a 20-year term at a fixed rate of 5 or 6%. 5 years ago, it was very conventional to enter into a 5-year term mortgage, and your rate and your monthly payment were fixed for 5 years. But now, with interest rates changing weekly and with the rates being increased substantially, although not totally recently, neither the mortgagee nor the mortgagor wants to commit himself to enter into a lengthy term at a fixed rate. And therefore, what we found is that many homeowners would enter into six-month term mortgages. And to a certain extent, they're inconvenient and they could be costly. I think at the moment, most financial institutions, when they renew a short-term mortgage, don't require a subsearch of title and a registered amending agreement. They're happy to rely on a letter agreement which says that we agree that we'll extend the mortgage for another 6 months, but this time you pay X%. All other terms of the mortgage remain unchanged. And I think that very few mortgagees have been burned by that. But I think the law is also very clear that the mortgagee is probably not entitled to that increased interest as against any kind of subsequent purchaser or encumbrancer, bona fide purchaser or encumbrancer for value, who obtains an interest in the land without actually being aware of that letter agreement. And if you look at the Reynolds extrusion cases mentioned in the materials, and if you look at that, I think it's probably a correct decision. So if we find that the mortgagees are going to start being burned by this, and they will if interest rates rise again, I think, then they're going to start requiring amending agreements, subsearches, and registration, which is then going to make it even more costly and probably impractical to use 6-month term mortgages for very long. The other alternative, I suppose, in the residential mortgage area, the mortgage is traditionally used as both evidence of the debt and security for the debt. But any of you who do a lot of commercial financing will know that usually in the commercial area you have a note which evidences the debt, and then the security is a charge on the asset which secures all indebtedness, and it's not tied to a specific note or a number of specific notes. And then the parties can amend or renew or change the notes without jeopardizing their security position, because the security is blanket security. And I don't think there's any real reason why that couldn't be done in the residential mortgage market as an alternative. What you would use, I suppose, it would have to be a demand residential mortgage, and you could insert a high fixed rate, say 30%. And then in the letter, which the mortgagee, and I certainly wouldn't do this with a private mortgagee, but with a financial institution, the letter would provide that the mortgagee, the financial institution, would not call the loan unless an event of default occurred. You could set out exactly what events those were. And that as long as the mortgagor pays interest at the rate applicable to the loan, then that would satisfy interest otherwise payable under the mortgage. That way, again, the security would likely be protected, notwithstanding that the notes were changed to reflect the circumstances in force at that time. In conclusion, I think the variable rate mortgage is a very useful financing instrument. I think it's becoming better understood by the public and better accepted by the public. But I think the most important thing from our perspective as lawyers is to make sure that any mortgagor who enters into a transaction of this nature understands exactly what the risks are and what the downside is as well. Thank you.
Okay, we're going to take a short coffee break. Would you, if you have any questions that you wish to put to the panel, a sheet has been given to you. Would you please complete it? Think about those questions during the coffee break and turn them in after, and we'll accept questions up until the end of the third speech. Thank you. Questions that arise due to the next two speakers, there'll be a very short period of time. If you can get the questions in to me, I'll distribute or ask the questions for the panel to deal with afterwards. And now we have Nancy Carnwath, partner of Macmillan Binch.
I hope you can hear this. Nobody told me I was supposed to wear a tie.
That's a sexist remark.
I've been allotted a somewhat hodgepodge of matters to deal with today, all of interest to be sure. In considering the contents of this paper, I was reminded of a charming story about a Toronto practitioner who died a few years ago. He was a very respected lawyer in town, but sometimes had his little eccentricities. Some of you may remember Mr. Harry Parkinson. When asked why he kept his miscellaneous file filed under the letter O, he said, "Well, O is for odds and ends. You may want to file this lecture under the letter O for the same reason." I'm going to be dealing first with matters of compounding and calculating interest. First, compounding. The compound interest has been defined as interest upon interest. Another definition quoted in the Oxford English Dictionary is that which arises from principal and interest taken together as it becomes due. And I think it's important to remember that you cannot compound until interest is due. And the way you compound is by adding the interest into the principal and then calculating interest on that aggregate. A typical clause in a mortgage relating to compound interest is set out on the first page of my notes. It's taken from the Dye and Durham form, but it's found in many mortgage forms. And it reads, "And it is hereby agreed that in case default shall be made in payment of any sum to become due for interest at any time appointed for payment thereof as aforesaid, compound interest shall be payable, and the sum in arrears for interest from time to time, as well after as before maturity, shall bear interest at the rate aforesaid. And in case the interest and compound interest are not paid in blank months, and in a normal monthly interest payment mortgage, you would fill in there usually either 1 month or frequently 3 months is filled in for the reason I'll mention later. Not paid in 3 months then from the time of default, arrest shall be made and compound interest compound interest at the rate aforesaid shall be payable on the aggregate amount then due, as well after as before maturity." Now, I've set out on this page 90 of the notes a schedule which shows how that is worked out mathematically if you're having to compute the interest and compound interest owing on a mortgage. Given a mortgage of $10,000 with interest at 12%, and if you've used the clause on the previous page with the 3-month period inserted, 3 months inserted, you've got a payment, say, due on January the 1st. 1 month's interest is $100. It's not paid, and on February 1st, another month's interest of $100 is payable. But the clause says if there's default in payment of any sum, compound interest shall be payable. So you can then, on February the 1st, also charge compound interest on the January installment, which is in default. That amounts to $1. On March the 1st, another $100 is payable, and you can charge then compound interest of $2, being $1 on the January payment and then $1 on the February payment. At that point, if you said that a rest shall be made every 3 months, you make your rest by adding the interest and compound interest into the principal to make a total of $10,303. And on the next installment, you calculate the interest on that amount. So the interest due on April 1st is $103.03. Now that is not really compounding interest fully. To compound interest fully is, in accordance with the Oxford Dictionary meaning, you should make your rest every time there's a payment due. So at the bottom of the page, you see the difference that arises from compounding fully. You've got the same figures, $10,000. The interest for January is $100. Add that into principal. You calculate in February the interest on $10,100. It comes out to $101. Add that into principal, you get $10,201. Calculate the interest on that, and you get $102.01. Add that into principal, and you see you have $10,303.01. Now that is 1 cent more than the amount on the schedule at the top of the page using the 3-month rest. 1 cent difference at 12% on $10,000 for 3 months. It's not very much. And that is the reason we often put 3 months into those schedules rather than 1 month, because if you're working those calculations out by longhand on a piece of paper without your little pocket calculator, it's much simpler, believe me, to do it just on round figures with the same interest calculation 3 times rather than have to keep adding it in and do a different calculation each month. So that is why that clause has sort of grown up in our mortgage forms. Sometimes it appears in the Dye and Durham form, for example, it appears for blended payments as well as for blended half-yearly payments as well as for simple payments of interest or interest plus principal. I think it's not quite as appropriate as another clause I'll mention later in that situation, but if you are using this form, the appropriate month to put in on a half-yearly calculation is 6 months, because the calculation and the compounding should be the same 6 months period there. There is a case which has dealt with that clause. It's Elman versus Conto on page 92 of the notes. And that was a case using this identical clause, but they had forgotten to fill in the months. It was just left blank. And the mortgagor argued that because that was blank, no compound interest at all could be charged. The mortgagee, of course, argued the contrary, and the courts agreed with the mortgagee that when you say compound interest, you infer that it will be compounded on the payment date, and that's what they held in that case. Now, there might have been another argument, of course, that you sort of partially compounded, as in the example at the top of page 90 in the notes. It wasn't worth anyone's while to argue that point, of course, because it only makes 1 cent difference anyway. As a matter of interest, I've shown at the bottom of page 91 another schedule showing the compounding using a more monthly factor of an interest calculated at 10% per annum, half yearly. Now, the equivalent monthly factor for that 10% per annum, as you're all familiar with, is 0.0081648,461. And if you're going to compound on a blended payment, if you're going to compound monthly, you have to use that factor to do your compounding. So we go through the same exercise on a blended payment, January the 1st, It's based on a $1,000 loan, 10% calculated half yearly. The interest due on January the 1st is $8.1648461. It's not paid on February 1st. There's another amount of interest accrued and due of the same amount. And on that date, we can also charge interest on the overdue interest, which in the second column of interest there is 0.0666647. On March the 1st, another payment, further compounding. And really, this sets out an example of a third way to fully compound. That is by continuing to add columns. You can not only add your interest and compound interest back into principal to calculate, but you can keep on adding columns as well. So I have carried this out to show the full compounding, or at least as full as necessary to come to the nearest cent. So I carried that through to the end of 6 months. At the end of 6 months, then you have your rest, because it's a half-yearly calculation, and you add in your interest and your compound interests. You see the little total there. That comes out to $50. Now, a simpler way to do that would have been to calculate 10% interest on $1,000 for a half year. And if you do that, it comes out to $50. It's much simpler than applying that factor every month. Calculation of interest calculation simply means to compute or to reckon. And the normal time to calculate or reckon what's owing on a loan is when you're going to pay it. That has been recognized and accepted by commercial draftsmen, and in commercial documents from time immemorial. A promissory note, demand promissory note, will set out the principal payable on demand with interest, say, at 10% per annum payable monthly. And that, the way of calculating the amount on that note, as all the banks do, is to take principal times interest times the number of days since the last payment divided by 365, or the total number of days in the year. And if the document also provides for compounding of interest, that compounding usually takes place when the interest is due and if it is not paid. Of course, if interest is paid, there's no compounding because there's nothing to charge the compound interest on. Confusion has arisen when installments are required to be paid on a loan at more frequent intervals than interest is to be calculated. And the common example with which we're all familiar is the blended monthly payment mortgage with interest calculated half yearly. I've set out at the bottom of the page a schedule, or part of a schedule from a loan amortization schedule of $1,000 at 10% calculated half yearly with the monthly installments of $11.84. I want to demonstrate that even on these type of blended payment mortgages, the axiom still applies that the payment date, the calculating date, and the compounding date, or the due date, all fall on the same date. Now, if interest is not to be paid until the end of a 6-month period, and in the meantime you're getting installments, what you have to do with those installments is add them or take them off principal, subtract them from principal. And at the end of your 6-month period, interest will be calculated on the reducing balance throughout that 6-month period of the principal. If we take our example as reflected in the loan schedule at the bottom of page 93, you see at the end of 6 months you've applied 6 installments of $11.84, which total $71.04. Take that from your $1,000 you started with, and you end up with $928.96. Now it's time to calculate the interest. So you first of all calculate 6 months interest on that $928.96 because it's still owing and it's been owing throughout the 6 months. The interest on that is $46.45. Then you take another 6 months interest on the payment that was just made. It was made on the 6th month, and so it's run the full 6 months. So that's another 10% for 6 months on $11.84. That amounts to $0.594. And for the payment that was made on the 5th month, 5 months interest had accrued on that payment before it was made. So you calculate 5 months interest to get $0.495, and so on for the 4th, 3rd, 2nd, and 1st installments. And you've then calculated the interest on the principal as reduced over that period, comes out to $48.51. If you then add back in or capitalize that, because the mortgage does not provide for an additional payment on that 6 months date, so you then compound it and add it back into principal, you get $977.47. And you'll notice that that is the exact figure that's shown on the loan schedule after the 6 month payment. The magic is not in this method shown on page 94. The magic is in the loan schedules, and they are arrived at by the actuaries coming up with the equivalent amount on those schedules to equal what would be the interest on a half-yearly calculation. Many years, not too many years ago, certainly when I started practicing, many of the mortgage companies, when you asked for a loan schedule, or not a loan schedule, I'm sorry, a mortgage statement, if you asked for it in the middle of a 6 month period, you would get a statement showing principal, which might be quite a reduced figure, with the interest, accrued interest, a very high figure. A couple of months later, after the 6 month gale date, you might get a statement from the same company on the same loan and find that the principal had gone up and the interest had gone down because they had capitalized that interest at the 6 month date, which put the principal back up, and then the interest was paid out and by capitalization, so the statement would show a low interest figure. Now that was the method that most mortgage companies used to calculate or to give their mortgage statements. It's not very convenient, though, because you don't sort of see the real relationship between what the principal and the interest is at any given time, except on the 6 month gale dates. And it's often commercially convenient to know that. So actuaries have been able to arrive at the figures referred to as factors, which when applied monthly to the outstanding principal will show an amount for interest in each month, the aggregate of which for each 6 month period is equal to the amount arrived at by the half-yearly calculation, which I've set out above. This enables the application of a proportionate part of such interest each month, which is more convenient in considering the status of a loan at a given time. The factor to apply to 10% calculated half-yearly is the factor I mentioned before, 0.00816484661. And that can be expressed as a percentage of 0.816484661%. In our example, there are then two methods of calculating interest. The first method is by calculating on each gale date a half year's interest at the rate of 10% per annum applied to the principal as reduced from time to time over the half year rather, by the application of the monthly installments if and when paid, with no compounding until the gale date. Thus, the calculating date, the due date, and the compounding date all fall on the gale date. The second method is by calculating on each monthly installment date a month's interest at the rate of 0.816484661%, and compounding at such rate each month if the interest so calculated is not paid. Thus, the calculating date, the due date, and the compounding date, again, all fall on the same date, namely the installment date. The first method is actually the method contemplated by the expression calculating interest half-yearly. But the second method using a factor to calculate monthly is its mathematical equivalent. In our computer age, it's the second method which is generally in use, and therefore it's understood when we say a mortgage is calculated half yearly. The confusion of these two methods and the confusion resulting from the thought that the payment date for installments on a blended payment mortgage is the due date for the payment of interest has resulted in the previously mentioned confusion in the use of the word calculated, and confusion as to when it occurs in relation to the due date and compounding date for interest. Further confusion has also resulted in the courts trying to prevent an injustice resulting from the application of Section 6 of the Interest Act. Marty has mentioned the Standard Reliance and Stubbs case, which was a case providing for 10% per annum with blended payments, and the court said, well, it didn't say calculated half yearly or yearly, and therefore we imply that if it doesn't state what the calculation period is, that it will be calculated yearly. That principle was carried forward in a number of cases because if it hadn't been applied, no interest at all would have been payable under Section 6 of the Interest Act. But the principle was picked up, unfortunately, in a case which didn't have blended monthly payments. That was the Fabasco and Abrams case, cited on page 97 of the notes. That case required payment of 9.5% per annum with no principal until maturity. And Keith, judge, taking the wording from the Standard Reliance and Stubbs line of cases, said that that meant that the 9.5 had to be calculated yearly rather than monthly, as had always been the case on straight interest payment mortgages before that time. It makes a considerable difference in the amount of interest that's actually payable, as you are all aware. As a result of that Fabasco case, other actions were taken by mortgagors to open up accounts which had been settled, or open up even mortgages that had been paid, to say they wanted some interest back. And the Turek versus 294-234 Ontario Limited is an example of that. But following the Fabasco case, another case came before the courts and went to the Supreme Court of Canada, the Metropolitan Trust and Morenish case. The trial judge didn't really agree with the Fabasco case, but he couldn't distinguish it, so he sent it over to the Court of Appeal. The 5-man Court of Appeal held that the Fabasco reasoning was correct and that the interest should be calculated annually. And the Supreme Court of Canada, however, reversed the Court of Appeal. The Supreme Court decision does not purport to overrule the Standard Reliance and Stubbs line of cases, but it does confine the application of the principle set out in those cases. That is, if you don't state what the calculation period is, it'll be annually. It confines that principle to blended monthly payment mortgages. It doesn't clearly state what the principle is in the Morenish case, but what the basis of the decision is that if the calculation period is not stated, interest will be calculated on the interest payment date, except for perhaps the Stubbs line of cases. Thus, we are back to the principles of calculating interest, which have always applied. I might just make a point that following the Fabasco and the lower court decision in the Morenish case, a lot of people started putting into their mortgages, if they had a principal at maturity, interest monthly payment, they added in that interest would be calculated monthly, just to be sure it didn't get an annual calculation. You have to watch yourself in putting that in, though, if you have a type of mortgage which is open for payment at any time. Because if you pay it within the monthly period, you're in the same bind as you would be having a half-yearly calculation and a monthly payment. That is, you have a shorter payment period than a calculating period. And you would have to work out some sort of factor, and there are none readily available in the texts for the daily basis on a monthly calculation. So I would suggest you don't need that now in view of the Morenish decision, and it could get you into trouble. The deemed reinvestment principle is a phrase used in a number of judgments, and I've set out the arithmetic of that principle. I'm not going to take time to go through that right now. I think it's clear, and I don't know that too much really turns on the deemed reinvestment principle. It's more or less self-explanatory in any event. I want to move on now to quite unrelated topic relating to legislation and case law affecting variable interest rates. There are a number of statutes which bear on this subject, and the Interest Act has been dealt with by previous speakers. With the Section 3, the cases under Section 3 now make it quite clear that you can set a rate of interest based on outside criteria. The Consumer Protection Act would effectively prohibit the charging of interest at a variable rate because of the disclosure requirements provided for. They require a disclosure of the cost of borrowing expressed in one sum in dollars and the percentage that the cost of borrowing bears to the loan. And you can't really calculate that in advance if you don't know what the interest rate is going to be. The Consumer Protection Act, however, doesn't affect mortgages, so we can forget about that as far as mortgages are concerned. Section 202 of the Bank Act also provides that there must be disclosure of cost of borrowing as prescribed by the regulations. There were regulations proposed and published in the the Canada Gazette in December 1980. Those have been under study for some time. At present, I think they're much revised from the Canada Gazette publication, but they're still under study. But one thing they do contemplate is different types of disclosure statements for a fixed rate loan and a variable rate loan. So in effect, they give official approval to variable rate loans by banks. The Mortgage Brokers Act is much the same as the Unconscionable Transaction, the Consumer Protection Act, in requiring disclosure of the exact cost of borrowing. And if I were a mortgage broker or acting for one, I would, and particularly if I felt that variable interest rates are the thing of the future, I would be lobbying for amendments to the disclosure requirements under the Mortgage Brokers Act, because those requirements could effectively put a mortgage broker out of business insofar as variable rate mortgages are concerned. There are prior to the new wave of variable interest rate type mortgages and loans, variable rates have been charged by banks for many years by way of demand loans. What happens is you go into a bank, the bank may say, well, we'll charge you prime plus 2%, or if it's me, they may say prime plus 5%. But then you sign a note and it's 10%. Well, in a week or two, you get a little notice saying, well, prime's gone up, your rate's now going to be X. And if you agree to that and pay it at the increased rate, the Royal Bank of Canada in Davidson case says you are bound to, you've accepted that contract and you are bound to pay it at the higher rate. If the bank, however, changes it and doesn't notify you, or if you don't accept the notification, then you're not bound. And that's the Bank of Nova Scotia and Casey case. My next unrelated topic is on the amendment to the Criminal Code, which provides for a criminal rate of interest. And I've set out the Section 305(1) of the Criminal Code, starting at page 106, which was passed or proclaimed on April the 1st, 1981. It makes it an indictable offense to contravene the section. It defines criminal rate as the effective annual rate of interest calculated in accordance with generally accepted actuarial practices and principles that exceed 60% on the credit advanced under the agreement. Or arrangement where the face amount of the insurance does not exceed the credit advanced. Interest is defined in, did I say that wrong? I think I lost my place there and picked up the wrong wording. Criminal rate is the effective annual rate is established by actuaries. And I wanted to point out that interest means the aggregate of all charges and expenses, not just interest as we commonly think of it. There's one case dealing with this section 305, the Mirror Design and Seascape case referred to on page 111 of the notes. That case actually came down in two parts because they went before the judge and then he sent them off to get some actuarial evidence. And then they came back and he decided what the result of their, they came back and agreed that it was a criminal rate, and then they got the decision on what the result in the particular case of that infraction of the section in the criminal code was. And that second decision, it wasn't reported at the time this paper went to be printed. It's now reported, if you want to take a note, at 23 RPR 219. That case involved a vendor of some property which he'd agreed to sell to a purchaser for cash, and then the purchaser couldn't come up with the cash, so it was agreed they would take back a mortgage, and the time for closing was expended a little bit, but it was important to the vendor that he get his money by a certain date, otherwise he wanted a bonus. So what they in fact, he wanted a higher price for his property if it was sold after a certain date. And the way they arranged that was to include in the mortgage back that after a certain date, instead of being $80,000 owing on the mortgage, there would be $100,000. Now, it was established that the result of that, plus the other interest provisions, exceeded 60% and was a criminal rate. The question then is, what was the effect of that providing for the criminal rate? There were really three results which could have come from the courts. They could have allowed the interest at the maximum non-criminal amount and just wiped off the excess. In this case, they could have wiped off the bonus. Or they could have allowed no interest, but sever the whole interest provisions altogether. Or they could treat the whole mortgage as void. What happened in this case was the court decided to strike out all the interest provisions completely, though they allowed the vendor to get back his principal. There was a prior case under a different statute, but a similar type of statute, the Stephen Investment and LeBlanc case, which had held that you simply wiped off the excess, the amount in excess of the criminal rate. So to a certain extent, those two cases are contradictory. There's some interesting annotation in the original judgment, original report on the Mirror Design case by Mr. Marvin G. Baer of the Faculty of Law of Queen's University, which I've quoted. He thinks it's ironic that this is one of the first cases reported under the recent amendments to the Criminal Code designed to combat loan sharking. The facts disclose no lack of prudence by the borrower, no unfair advantage taken by the lender, and no illegal duress in collection, the usual attributes of loan sharking which attract public condemnation. It just points up that section was put in to combat one evil, and it's made a bit of a nightmare in trying to structure loan transactions. In the particular facts on the case, the Mirror case, really it's not unusual to want a higher payment after a certain date. Companies often provide for that. If they close a deal early, you can get a reduction in the purchase price. Similarly, on participation and equity financing, you can easily run into trouble under that section. Our office recently had occasion to consider this on a very large equity-type transaction. We sought the advice of actuaries because the section refers to actuarial principles. And what we found in consulting actuaries that they don't have a body of principles as clearly and widely defined as generally accepted accounting principles. If they're given a problem such as the future intangible interest, they will consider it and consider principles and the practice and come up with something, but it would be an opinion which would be qualified. So you're not going to necessarily in a given situation get a definite answer from the actuaries. We have decided in our particular case that it was prudent, therefore, to put a rider on the loan agreement to provide that if the rate provided for exceeded the criminal rate, then that wouldn't be included. And I've set out on page 115 of the notes the clause we used, which you may find useful as a precedent. I want to mention briefly the Unconscionable Transactions Relief Act and also the common law on unconscionable transactions, that those considerations may have an effect on the interest that can be charged or which the courts will allow. The Act provides that where in respect of money lent, the court finds that having regard to the risk and to all the circumstances, the cost of the loan is excessive, and that the transaction is harsh and unconscionable, the court may reopen the transaction and take an account between the creditor and debtor, and they can do various other things. They can cut down the amount of the loan, or they can set it aside altogether. I've set out a summary of some of the cases under that legislation. The first one was the Attorney General in Barfried. Dave Milman mentioned that in his talk, that it was the one where the Supreme Court of Canada considered whether that was an act dealing with interest, which would therefore be ultra vires the provincial legislature, and they decided it only incidentally dealt with interest and therefore was intra vires. The principles that come out of the cases under that act are that the act is only to correct situations where unfair advantage is taken of the borrower, and only to the extent that there is a clear and unequivocal authorization for revision. Factors to be considered include the honesty of the lender and his fair dealings and full disclosure in terms intelligible to the borrower, the relative positions and experience of the parties, the risk taken by the lender, and the cost of the loan relative to the cost in prevailing market in the same area for the same type of loan with a similar risk. And it's also been said that to trigger the act, the court must find both that the cost of the loan is excessive and the transaction is harsh and unconscionable. Similarly, on common law cases, just under the heading of unconscionability, similar type of principles have evolved. I've set out some of the principles that have come out of those cases. One, the entire transaction, not just the impugned loan in isolation, must be viewed in considering unconscionability. Material elements of unconscionability have been described as inequality in the positions of the party arising out of ignorance, need, or distress of the weaker, and substantial unfairness of the bargain thus obtained by the stronger, and so on. The question might be posed as to whether loans bearing interest at a variable rate might be considered unconscionable. It would appear from the cases that the legislation above referred to and the common law that a variable rate would not be considered intrinsically unconscionable. To end these odds and ends, I want to touch briefly on the question of interest after maturity and interest before and after judgments. First, interest after maturity. If you don't state in your document that interest is to be charged at the same rate after maturity as before maturity, you won't get it. The Supreme Court of Canada in the Hossack and Shaw case, which I've quoted there, says to carry the contract for the stipulated rate beyond the maturity of the loan explicit provisions to that effect must be made. Similarly, on interests on judgments, the document must state if interest is to be payable after judgment. In the case of Economic Life Assurance Society and Usborne, Earl of Halsbury quoted Fry L.J. in the ex parte Fewings case to the following effect. When there is a covenant for the payment of a principal sum and a judgment has been obtained upon the covenant for that sum, it is plain that the covenant is merged in the judgment, and if there is a covenant to pay interest which is merely incidental to the covenant to pay the principal debt, that covenant is also merged in the judgment on the covenant to pay the principal debt. Of course, the covenant to pay interest may be so expressed as not to merge in a judgment for the principal. For instance, if it was a covenant to pay interest so long as any part of the principal should remain due either on the covenant or on the judgment. Now, I think you'll find that most of the standard forms in use in Ontario do explicitly provide that interest will be payable at the mortgage rate after judgment. In the defeasance clause, you normally have the statement that the interest provided is to be applied before and after maturity and before and after default. And usually the judgment clause is a separate one you'll find buried in the mortgage that provides that there's no merger on taking of judgment, and it doesn't affect the mortgagee's rights to interest at the rate and times provided in the mortgage, and that the judgment shall provide that interest thereon shall be computed at the same rate and in the same manner as provided in the mortgage until the judgment is fully paid and satisfied. Now, I just noticed in the all-weekly summary report that hit my desk yesterday, it's this week's all-weekly summary, there's an Alberta case which held that though a mortgage which provided for interest at the same rate after maturity and after default, and also provided that there would be no merger in the judgment, but apparently didn't explicitly state that there would be interest at the same rate after judgment, was held not to bear interest at the same rate after judgment. So you had to be very explicit and very full in your clause in the mortgage. I'll mention sections 12 to 15 of the Interest Act, which these deal with interest that can be provided after judgment, and they say that, or provided can be allowed on a judgment, and they allow for only 5%.